it comes to finding people's places, finding that employee's personal place of abode to sue them personally for the purpose of service of process, aka joinder of party, aka evoking personal jurisdiction through service of process. So you know the name of the employee, but you don't know how to join them personally. And of course, in the past, we've also spoken about the importance of how to join people personally and how personal suits are evoked based on service of process. So now we're here talking about the power of subpoena. So you know the name of the employee, but you don't know where they personally domicile for the purpose of evoking personal jurisdiction through summons or waiver of summons. You can obtain that through a subpoena. But the question you should be asking is, what does a subpoena constitute? What are the limitations to it? It is very deep and quite complex, but we'll simplify it by tearing it down a piece at a time. About Rule 36 and 38. It basically lays down how you can pierce anybody's private information, whether you realize it or not. And part of that was explained in a text post on Patreon regarding the 6 types of discovery. On the note of subpoena, it gives you a basic outline of what it is. See, none of these rules, when it comes to subpoena, succinctly, distinctly, and specifically tells you, hey, here's a section dedicated to subpoena, so we're going to detail it. No. Instead, they scattered the principles behind how subpoenas will be used and enforced all over. I'm making it easier for you. I'm gathering all the puzzle pieces and I'm bringing it into one place. I'm taking all the different jewels and I'm giving it and handing it to you with an explanation. Rule 30, deposition by oral examination. If you're looking for subpoena and you read this rule, you will think, oh yeah, it's not here. Let me move on to the next and see. In other words, if you use the title of these rules as the marker for where you think your answer is, you would just pass your answer by without realizing what you've just done. Keep in mind, if a tortfeasor is an employee of any given entity, private or public, and you just know their first name and you don't know their last name, or you know the first letter of their first name and you know their entire last name, but the one common denominator between that name that you know and the act of that tortfeasor is their employee. That means you can now go to their employee and say, hey, provide. A deposition is the formal act of sitting someone down, either by using a notary or by using a stenographer, or, quote, by anyone who is allowed to take oaths in any given jurisdiction, federal, state, or locally, aka county. But guess what? Depositions also exist in form of writing, aka attachment, aka interrogatory. A deposition takes place either physically, where you do it in a form of question and answer, or on pen and paper where it's done in question and answer format, likewise, called an attachment interrogatory. Do you see? Method of recording. The party who notices the deposition, aka the subpoena, remember, deposition is just enough, and that goes to the people sending first, second notice saying they're doing the administrative process. That administrative process that you're doing has no standard unless you're planning to sue someone, unless you will sue someone, and unless you're using it as a setup, or it is part of your setup since you've already sued. But if you just send in some administrative process thinking someone is going to move and shake because you send it to them, it might work and it might not work. And you might be playing in fire, especially if your security of shelter, monies, livelihood, and freedom is involved. If it's just some other stuff, some minor situation, yeah, have your fun, send all the notice, jump in a hype train, enjoy the ride, have fun on pen and paper, no problem. But if it's something serious, it'd probably be best for you to know how it works and how you can truly grab them by the balls, rather than just reading some stuff, hearing some stuff on social media, and just jumping in the bandwagon and say, all right, I'm going to title this first notice, second notice. Now you have to respond or else I'll do a default notice without you even realizing what default notice is applicable to compared to its counterpart as applicable to what you're trying to do called a summary judgment, which a whole separate video is done on that on YouTube. But anyway, methods of pre-trial conference, not an arraignment, not an arraignment. Arraignment is just letting you know, hey, we're charging you with this and we intend to hang you. And that's applicable in criminal matters, in civil matters, whereby there's no obligation of penalty by jail time, imprisonment, or fines. But there is the obligation of forfeiture, whereby you can attach someone's personal or real property or estate, aka their interest, and other types of property after a judgment in a civil case. Equivalence within said civil proceeding and such. These are tools that you can use to make all the difference. These are tools that I don't even think I've ever seen any, quote, pro se litigants or anyone who don't use attorneys or anyone who say they have rights. They don't even know about this. They don't even use this. Yet they tell you, demand for discovery. Do discovery. They can't move forward without discovery. If they don't see you do this, they will run tricks around you and they will laugh at you in front of you and behind you and truly put you in kangaroo courts. These are the things that you do that set you apart from the crowd. These are the things that you do that truly makes them shake and sweat. The things that you feel when they send you paper and notices, they will feel it when you begin to do these things. These are the things that you do that makes them run to you with settlement checks. In case you don't realize it yet, the complete 24-minute video is on the Patreon page. Take care. Best of luck.